for an offense that occurred on January of 2008. And the question really is, where do we find justice in all of this? Where can the family find justice? Where can the court find justice? Where can the defendant find justice when we're dealing with one count of sexual conduct of a minor that's a Class 6 felony? And I know that the defendant pled guilty straight up to the court, and the court has complete autonomy to do whatever the court deems to be appropriate. But the state does want to point out a variety of different things. First, as I said, the relationship did start back in December. And when I say relationship, I don't necessarily mean a sexual relationship, but I mean the grooming relationship. And I would suspect that the grooming relationship started sometime before that, because a relationship had to be built, not just with Courtney, but with her parents. That trust had to be built. That foundation had to be built. And that most likely started some time ago. We do have information of some type of kissing, touching going on in December of 2008. And I'll be very, very forward. I didn't charge those. That was a strategic decision. And the reason why it was a strategic decision was because it would create different issues of consent, and it would question where the state needs to go from here. So as handling the case in an appropriate direction, the state made a choice, a decision, to proceed forward with one count. But you can't ignore what was going on in December. And you can still keep that in context, and the court can still consider it for texture. The entire relationship in this case impinges on trust. It's built on trust. It's not just the trust of Courtney, but it's the trust of her parents. To Courtney, this teacher was somebody not just that she respected, but somebody that she thought she could believe in, that was going to help her go to college, be a great athlete, and somebody that she thought genuinely had her best interest in heart. For her parents, this person was welcome in her home. Her parents allowed her to drive her home from school, continue this coaching and a friendship, and they also believed that she could help her. There is emotional harm, not just to the parents in this case, but also to the Courtney in this case. I know that everybody has their personal opinions on where the victim in this case is at emotionally, but I'm here to tell you, Your Honor, this is a child, and she's a child, 15 years old when this happened, that was vaulted, not by choice, into a situation that was highly publicized, that was highly scrutinized, that the entire community knew about, and she still went to school. Every day she went to school. And something that is so private as sex, something that is so personal as an intimate encounter, she's now been vaulted into this situation. And it's not just the fact that she was a victim, it's the fact that all of this is out there and it's shared with everybody. Everybody knows, and she can't get away from it. She can't go to school and get away from it. She can't go home and get away from it. She can't even go to her room and get away from it. It is constantly with her. So to say that there's no emotional harm to Courtney would be unthinkable, because there is. There's emotional harm to the parents, because let's face it, a parent is not equipped to deal with this situation. A parent is not equipped to deal with anybody hurting their child, let alone somebody that they welcomed into their home and somebody that they trusted. The devastation on the family has got to be considered as an aggravating factor. She was the teacher. She was a friend. They had a relationship of sorts, whatever you want to call it or classify it. There was some type of relationship for the purpose of grooming. They spoke on the phone. They spoke on MySpace. They text messaged each other. There was contact that went on consistently. Was it an appropriate relationship? Absolutely not. Was it something that Ms. Anderson should know that it was inappropriate? Absolutely. Does she call her other students and do that? Does she text her other students for hours on end? Is she friends with her other students on MySpace? That's not appropriate behavior for a person in authority. That's not appropriate behavior for somebody that is given and it's automatically anticipated that type of power and respect. It's not appropriate. I also looked at all the mitigating factors, and I agree. There is a lot of family support here for Ms. Anderson. And she grew up in a wonderful home. And for that, I'm glad. But I don't see it as a mitigating factor. And the reason why I don't see it as a mitigating factor is because we work in this job every day. And we see defendants from all walks of life every day. And some of them have been through the worst of the worst of the worst. And she's been given the best of the best of the best. And when I look at this, my question is, well, what is your excuse? You have all of these people around you. You have all of these people that love you. And you have people that are willing to move mountains for you. Why didn't you go to one of these people? Why didn't you seek out help from one of these people? So I don't see it as a mitigating factor. What I do think is mitigating is that she's never been in trouble before. She has no prior felony convictions. And I also see as a mitigating factor that when she was contacted by the detective in this case, she was very honest about what happened. So I do see those two things. And, Your Honor, I know the court is well aware of what the family wants, and this has been discussed to the nth degree. Ms. Anderson needs treatment, and she needs to be on probation. There is no other opportunity. There's no other option. Either send her to jail, prison, with no treatment, or place her on probation and provide that treatment. She does need to be monitored. She does need to earn a misdemeanor in this case. She does have something to prove, not just to herself, but to her family, and certainly, most importantly of all, the victim and the probation department, because that's what is going to make sure, and that's what's going to temper the actions to the safety of the community. So, Your Honor, we would ask that you sentence Ms. Anderson to probation. I know that the family wants no less than lifetime, and that was something that they would like to see. And in a lot of ways, I can see that as very, very important. But I also know from a court's perspective that it's not really sensical to put somebody on lifetime probation and leave a felony undesignated. Because theoretically, they may not necessarily work together. And if that's the court's position, she needs to be on lifetime for a substantial amount of time. No less than 10 years, no less than 20 years. Because she needs to earn a misdemeanor in this case. She needs to do what she's supposed to prove not just that this isn't going to happen again, but to prove that she's done everything she needs to do so that this never happens again. We would also ask that there is an initial jail time. Not a lot of jail, because obviously we're talking...
Sure. Stand recess for just a minute. Back on the record in CR 2008-108-052-001, State of Arizona versus Susan Jane Anderson. This is the time set for continuation of sentencing. Ms. Andrews, please proceed.
Your Honor, as I was previously saying, I think that Ms. Anderson needs an initial jail term. Not a lot of jail, a weekend, enough time to make a point, enough time not to punish her, but to make her realize how serious probation is, how serious what she did is, and how serious we take her actions. We would also ask that the court require her to register as a sex offender. That's statutory for this type of offense, and I think it's absolutely necessary for this type of offense. Thank you.
Thank you.